The best way to make money on AI is to break any law necessary to reach endgame before the competition, because trillion-dollar companies can lie, cheat, and steal their way to having the best LLM and worry about paying the fines and legal fees later, because the fines will always be lower than the omnipotent shareholder value. And Meta joins us today because Meta is pirating content for its LLM, something that normal end users aren't allowed to do within the law. But if you're a trillion-dollar company, then go for it, I guess. Weirder still is that a judge just said that this is okay. It's fair use, which is a particularly hot topic for us right now, and it feels a little bit like a double standard sometimes. Now, individuals, as in normal people, have been prosecuted at various points over the decades for piracy of content, music or whatever it may be, and it seems that the little guy is told from governments and large companies, record labels, huge trillion-dollar entities, that piracy bad. But if you're Meta, it turns out, fuck you. When mega corporations do it, it's justifiable. It's okay. Suddenly, downloading things you'd normally have to pay for is no problem. They don't even have to pay for it once. They literally just never pay for it at all. It really feels like these multi-trillion-dollar companies, like Meta in this case, get different rules than the rest of us who have to deal with things like copyright claims or fair use and your justification of why something's fair use and the GNCA system. This is very interesting to us, though, because of our recent experiences with Bloomberg. So fair use is a fact-based defense. It is specifically a defense where in a court, you would use it to illustrate why you think your use of a set of copyrighted work is fair use, and therefore you don't need permission or licensing. You can just use it to further newsworthiness, commentary, criticism, education is another one, parody is another of the optional criteria you could meet. There's a lot of ways to use fair use in a defense. And then there's another part that's really not nuanced. And the part that has no nuance with fair use and with GNCA takedowns is how they function on YouTube. So GNCA takedowns on YouTube instantly take down a video, they apply a strike to the channel, and then you have to deal with it as the creator, whether or not you are actually infringing any copyright. If there's no further action, the content goes back up, the strike is removed, everything's back to normal, except the creator gets punished for those 13 days, and the content is suppressed and basically killed. So it does feel like a sort of double standard where Meta recently used copyrighted materials in training its LLMs. There were disputes over that and the legitimacy of it and whether or not they need licenses. Meta, in the meantime, is able to continue using those materials unless an injunction of some kind is filed, and it's able to continue profiting on those materials, and everything can stay up, operational, and function as normal while they go deal with the disagreement, the legal disagreement, the lawsuit, either behind closed doors or in court. Meta was sued by at least 13 authors in the particular case we're talking about today. There's a judgment. It was found to be under fair use. There are aspects of the case still ongoing. Up until this moment with LLMs, these huge companies, they really cared about protecting their own intellectual property to the point of making examples out of random individuals who might have downloaded music or redistributed it through seeding in a torrent network or something. And that wasn't a common case to bring in front of a judge, but there were a few instances of people being prosecuted for that. We brought you this video with our black market GPU backer tiers, since our deep dive investigation was taken down by an illegitimate copyright strike by a multi-billion-dollar corporation. We're closing these tiers soon as we begin to prepare to ship them out, but while they're still up, you can get exclusive bonus videos that are included with packs that have a variety of our store items, all of which fund GN and GNCA directly. Some of these include our new Blind Eye t-shirt that we designed, our blacklisted no-logo t-shirt that's fitting for GNCA, our new pint glasses with GPU VRAM art, and every single tier also receives a USB key with a copy of the movie itself on it. That way, we can ensure that everyone can be a part of preserving it, no matter how many times it's taken down by different companies. Head over to store.gamersnexus.net to grab one of our backer tiers now, or any individual item, like the Blind Eye t-shirts. Thanks for your support. The Meta story is interesting to me because my personal views on copyright and fair use have really changed a lot over the years. They've evolved or matured a lot over the years, where back in the day when I wasn't making any money, I could barely afford to live, and I was publishing charts that took, at the time, what felt like all of the money I had out into the wild, and then they got republished on other publications in their entirety or mostly entirety. That felt a lot different than it feels today. These days, as long as someone republishing our work, like our charts, is expanding on it or adding to it in some way that benefits the consumer, then fucking go for it. Get it out there to the consumers. show them the data, and then expand on it with your own analysis. Transform it. And that word's going to be critical today, that word transformation or transformative use. As long as someone's doing that, I am all for it, as long as the information's out there to the person who needs it. Now, back in the day, I was much more aggressive in engagements where this would happen, where people would republish our works or our charts in their entirety. It felt a lot worse back when you couldn't afford anything. Just don't take every single chart that we made, republish it, write an introductory 1 or 2 sentences, and then an outro 1 sentence and call it a day, because that wouldn't be transformative. But that's why this is a complicated subject. You can have inconsistent or conflicting views on different aspects of copyright, because copyright is nuanced and complicated. And as a result of that kind of change, personally, of my viewpoints, that paradigm shift, I view this meta thing through a kind of complicated lens. Now, Meta is using all this to make LLMs, and they're arguing fair use. I've been on both sides of that argument. I have argued against it and for it. But Meta, there's a key difference here. Meta is not a publication that is reprinting some work and trying to build upon the knowledge of a reader base. Although there are publications that just copy-paste stuff also, and that's not cool, but that's a different story entirely, because that's a much harder line to draw. What Meta is doing is instead ingesting the information and then using that to generate potentially trillions of dollars of the omnipotent shareholder value, and then spitting it back out as a product that might actually hurt consumers long-term with its LLMs. Here's what's going on. There's a lawsuit that recently went through the court system where 13 different book companies or authors were suing Meta, and it was for what they said was unlawful torrenting of their copyrighted works and materials in order to train Meta's LLMs without consent. Meta actually initially began seeking licenses for this, making it look like they believed they needed one at all, and then later decided, nope, that's too much work and it costs money, never mind, let's just take it instead. And that is actually pretty much how it went. We'll get to that. So federal judge Vince Chabria has provided a ruling on this case and sided with the trillion-dollar company. This ruling will likely pave the way for other massive AI and LLM-type companies to justify and defend their actions in the future for training their LLMs. In his summary judgment, Judge Chabria wrote, quote, "Given the state of the record, the court has no choice but to grant summary judgment to Meta on the plaintiff's claim that the company violated copyright law by training its models with their books," end quote. No choice. None at all. In what looks like a mountain of evidence, though, against Meta, it brings us to the question of how we got here. So in this video, we're going to analyze what Judge Chabria wrote in his 40-page summary judgment, but the short of it is that the judge reasoned that Meta's use of copyrighted material comes down to fair use. He believes this so much that those words were uttered 81 times in the summary judgment, and Meta used the data in a transformative way, he says, which is a word that was mentioned 26 times. Simply put, the judge asserts that Meta AI doesn't regurgitate books wholesale to people, and therefore everything's okay, and he says this essentially puts the company in the clear. Now, this comes over 10 years after the arrest and prosecution of Reddit co-owner at the time, Aaron Swartz, who was indicted for a series of charges in connection with the downloading and distribution of scientific journals and written works that are typically locked behind paywalls, similar, in our opinions, to the data obtained by Meta in some instances. Unlike Meta, though, Swartz was famously arrested and had the possibility of 50 years of prison for the alleged felonious downloading and distribution of journal resources and academic materials, eventually leading to his death. 14 years later, and suddenly it's fair use to ingest data like that for training an LLM, just not to distribute it for actual education of humans directly. Let's delve into the specifics of what the judge said. We'll start with a timeline. This is an important case to the future of copyright law and data scraping for purposes of generating profit via training. Here's how it went down. Meta had torrented millions of copyrighted materials from shadow libraries like LibGen or Library Genesis, which a Meta employee internally acknowledged as a, quote, data set we know to be pirated, end quote. The plaintiffs, the authors, assert that, quote, Meta torrented at least 81.7 terabytes of data across multiple shadow libraries through the site Anna's Archive, including at least 35.7 terabytes of data from ZLibrary and LibGen, end quote. In discovery, a Meta employee acknowledged the seeming nefariousness of the situation and stated in an internal message that was sent out October 19th, 2022, quote, I don't think we should use pirated material. I really need to draw a line there, end quote. A different Meta employee stated, quote, using pirated material should be beyond our ethical threshold, end quote. Of course, The real news here is that Meta has those to begin with. Responding to a question of whether it was problematic to use data from resources like Sci-Hub, ResearchGate, and LibGen, the employee replied that they are, quote, basically like Pirate Bay or something like that. They're distributing content that is protected by copyright and they're infringing it, end quote. Great things to put in writing. I'm sure the lawyers loved that at Meta. On January 17th, 2023, there was an internal message implying that Meta CEO Mark Zuckerberg, quote, wants to move the stuff forward, end quote, followed by communications that read, quote, we need to find a way to unblock all of this, end quote. April 17th, 2023, Meta went so far as to try and figure out how to conceal its torrenting efforts, with one Meta employee writing, quote, can we load LibGen data using Meta IP ranges? Or should we use some VPN, end quote. April 21st, 2023, a few days later, the employee stated in internal comms, quote, torrenting from a corporate laptop doesn't feel right, which was followed by a laughing face emoji. September 5th, 2023, the same staffer said that, quote, using torrents would entail seeding the files, i.e. sharing the content outside. This could be legally not okay, end quote. It turns out, Meta, quote, modified the config setting so that the smallest amount of seeding possible could occur, end quote. Allegedly, the company also didn't use Facebook's infrastructure to download this data to, quote, avoid risk of tracing back the seeder or downloader from Facebook servers, end quote. In its defense, Meta stated that, quote, it took precautions not to seed any downloaded files, end quote. The company's lawyers added that, quote, plaintiffs thus plead no facts to show that Meta seeded plaintiffs' books, end quote. Now, all of this sure looks guilty because, in the very least, they took steps to obfuscate what they were doing, that they were doing something questionable or wrong, and tried to hide that. And when asked why Meta decided to minimize seeding or the redistribution of bits of the files it had downloaded, Tom's Hardware reported that the company asserted attorney-client privilege, something that can't be discussed because it was between the lawyers and the company, which really doesn't help them here. Now, we'll work mostly top to bottom to analyze key phrases and statements from the judge as well, because we don't think this was there's a lot of biased and loaded language in here from the judge and his judgment in the summary. We disagree with a lot of it, so we're going to go through that too. Quote, because the performance of a generative AI model depends on the amount and quality of data it absorbs as part of its training, companies have been unable to resist the temptation to feed copyright-protected materials into their models without getting permission from the copyright holders or paying them for the right to use their works for this purpose. This case presents the question whether such conduct is illegal. Although the devil is in the details, in most cases, the answer will likely be yes, end quote. So he concludes that AI models ingesting copyrighted works should be illegal in most cases, and despite that, his bias begins to show with this sentence. Again, the quote here being that companies have been unable to resist the temptation to feed copyright-protected materials into their models. Because companies can make money, they are unable to resist taking anything they need to in order to do so. That's easy logic to follow. So, because politicians like power, they're unable to resist lying. Because judges individually like money, they're unable to resist the possibility of a bribe. Because corporations want profit, they're unable to resist selling out the consumer. Because the impoverished need to eat, they are unable to resist stealing from the rich. No, wait, not that one. That's not okay. Never mind. Cut that. Editors, cut that. That one is not okay. Meta had no choice but to steal copyrighted data. It can make them money. The judge then goes on to say, quote, it is generally illegal to copy protected works without permission. As a legal matter, it's true that you're less likely to be liable for copyright infringement if you're copying the work for a transformative purpose. In that situation, you're more likely to be protected by the fair use doctrine, end quote. Now, that's something we know a lot more about than ever before. It's interesting that the law of the GNCA is structured on this presupposition that the free media reporting on something newsworthy, we're just the big mega corporations, they're just going to say it's not fair use, and then worst case scenario, they're wrong, and they can at least silence people for 10 to 13 days on large platforms before they're unsilenced. But in other words, it's structured as a guilty until proven innocent platform. A strike is filed on a platform like YouTube, and then you are guilty until they either do nothing and it's supposed you're innocent, or until you're proven innocent, and in both cases you're offline a long time. Yet for Meta, it was the opposite. Meta was innocent until judged otherwise. The judge paraphrased the plaintiff's arguments and wrote, quote, "The plaintiffs offer two primary theories for how the markets for their works are affected by Meta's copying. They contend that Llama, Meta's large language model, is capable of reproducing small snippets of text from their books. And they contend that Meta, by using their works for training without permission, has diminished the author's ability to license their works for the purpose of training large language models," end quote. He dismisses these arguments, though, writing, quote, "Both of these arguments are clear losers. Llama is not capable of generating enough text from the plaintiff's books to matter, and the plaintiffs are not entitled to the market for licensing their works as AI training data," end quote. The judge went on to say that Meta, quote, "post-trained its models to prevent them from memorizing and outputting certain text from their training data, including copyrighted material," end quote. The judge says that no more than 50 words could be reproduced from the plaintiff's books. Now, we attempted to test this with the books specifically named by the plaintiffs in this case. Although Meta spat out a few sentences of books, none of them were accurate. It made them up. They were often in the style of the author, but the words were not precise and tended to just not be at all what they wrote. So maybe Meta's defense is that its AI is incompetent. After all, it's not illegal to be an idiot. The lawsuit states that the authors could reproduce sentences. It's possible that Meta has changed how the LLM behaves since the suit, though. Now, we tried something else. We were able to get it to produce some materials from the D&D Player's Handbook 1 3.5 edition, which, first of all, and obviously, is at my desk at all times. Now, Meta AI was able to accurately reproduce the two-handed weapon damage table that is in this book, the Player's Handbook Core Rulebook 1 version 3.5 edition for Dungeons & Dragons published by Wizards of the Coast, and it was able to get the two-handed weapon damage table correct, but it really fucked up on the Ranger. And you don't fuck up the Ranger table because that's when I'll notice. First of all, it was able to accurately reproduce the base attack bonus and the fortitude, will save, and reflex modifiers throughout most of the levels, but where it screwed up was by saying that you don't get a combat style choice subcategorization at level 2, which is a massive oversight for the Ranger. As we all know, page 46, table 313, subtitle, The Ranger, it is shown that you get combat styles at level 2. Additionally, you don't get hide in plain sight until level 17, but Meta thinks you get it at level 10, which would make Rangers massively and unbelievably overpowered. And so Meta is able to reproduce some things accurately, but it seems to struggle with others. It's mixing and matching them. And what was the... Look, we tested this mostly because we're nerds and it was amusing to me. And I got to test my memory of the Ranger table from over a decade ago. But the point is, Wizards of the Coast was not a named plaintiff in this, and Wizards of the Coast is highly litigious, and this is one of the most pirated books of all time. You can find PDFs of it all over the internet, especially back when 3.5 was common. But what we can't prove and what we don't know is where Meta got this information from. So if you just ask Meta directly, the LLM, which surely would never lie to you, it says that it sources it from a variety of places. This could include the internet, which it is attached to in at least some capacity. And so in this situation, it's not clear where it's pulling the material. If it is pulling it from multiple published sources and recompiling it into some kind of aggregate or composite of information, then that's really not much different than what a website might do if they're trying to take a bunch of disaggregate material, put it together, and then present it to you and say, here's everything you need to know about the Ranger. But this is a nuanced case, and this discussion kind of proves that through a strained metaphor. You're welcome. Anyway, the judge goes on to say, quote, as for the potentially winning argument that Meta has copied their works to create a product that will likely flood the market with similar works, causing market dilution, the plaintiffs barely give this issue lip service, and they present no evidence about how the current or expected outputs from Meta's models would dilute the market for their own works. If the law allowed people to copy your creations in a way that would diminish the market for your works, this would diminish your incentive to create more in the future. Thus, the key question in virtually any case where a defendant has copied someone's original work without permission is whether allowing people to engage in that sort of conduct would substantially diminish the market for the original work. Because fair use is an affirmative defense, the burden of proof is on the party invoking it, end quote. It's kind of like in the Bloomberg situation. We are not a market replacement for that clip of the president, which we already talked about in a separate video. It's tough to actually quantify what the impact would be from any of this. Elaborating on the definition of fair use, Judge Chabria cites the Copyright Act, which states, quote, the fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright, end quote. He also writes that, quote, fair use is a flexible concept, and wrote, quote, although Meta needed and acquired and used a wide range of training data, it especially needed books, because, as discussed above, books make for high-quality data, end quote. To us, this language comes across as incredibly biased for the judge, where the judge is saying that Meta needed this information, and the only way to get it was to steal it. We're not even going to require them to pay $10 to buy it on Amazon, apparently. They can just take the copies and do what they want with it, and that's because they need it. And this is pretty easy logic to follow once again, because if you have someone who needs a car because they can't get to work without it and they'll lose their job, then they can just steal the car, and then they can get to work, and it's okay because they had a valid reason to take it. If a man is starving and might die and actually needs food, as in need, the definition of the word need, not want need to make money, then we have a hard time believing that a man starving would be found innocent of theft just because he needed it to eat. It seems, again, that if you're a $1 trillion company, the rules are a little different. Judge Chabria continues to use more biased language when describing Meta's perspective. Quote, at first, Meta wanted to license books and so tried to negotiate licensing deals with several major publishers. Meta's head of generative AI discussed spending up to $100 million on licensing, but as negotiations proceeded, Meta realized that licensing would be more difficult than anticipated. Boo fucking who? Sorry, that's not in the quote. I added that. For one thing, the quote continues, publishers generally do not hold the subsidiary rights to license books for AI training. These rights are instead held by individual authors, and there's no organization for collective licensing of such rights, end quote. And to quote a common Lewis Rossman phrase, cry me a fucking river. This, to us, the entire paragraph illustrates that Meta knew it was in the wrong and decided it would be cheaper, and it's right, to take a gamble, and if there are fines, pay them later. And it was right, except there wasn't even a fine. The judge continued, quote, for another thing, some publishers apparently ignored Meta's outreach, and only one gave Meta a pricing proposal. In spring 2023, after failing to acquire licenses and following escalation to CEO Mark Zuckerberg, Meta decided to just use the works acquired from LibGen as training data, end quote. So because they were ignored, they just took it and said, this is such problematic language. And again, going back to the car theft analogy, it's like, if instead of just stealing it, you first asked if you could buy it and the owner didn't respond because they're not selling their car, then it's okay to take it at that point because you at least asked first and you tried. Finding out that they're not willing to sell the data and then taking it anyway seems like it's a lot worse than having just taken it. It seems harder to defend fair use. There's a level of intent there when it's done in this order. And it doesn't make the theft more acceptable just because at one point you offer to pay for it. The corporate bootlicking doesn't stop there either. Judge Chabria stated, quote, to download these large data sets more quickly, also known as quicker, and without unnecessarily slowing down its networks, Meta torrented them, end quote. To get the music faster without having to get off the couch and go to the store, the defendant just downloaded it from Napster and LimeWire. To get the car quickly without slowing down the suspect's day, they just took it instead of going to buy one. That would take hours. As far as the infringement, here's what they say. Quote, with respect to the plaintiff's claim that Meta infringed their copyrights by distributing their works via leeching or seeding, neither side moved for summary judgment, so this will remain a live issue in the case, end quote. Regarding torrenting, Judge Chabria wrote, quote, there's no dispute that Meta torrented LibGen and Anna's archive, but the parties dispute whether and to what extent Meta uploaded via leeching or seeding the data it torrented, end quote. Based on this, it seems like the judge isn't concerned about whether Meta downloaded copyrighted books, only if the company shared copyrighted works it downloaded. Now, it's been a while, at least as far as I'm aware, but people have been in the past convicted for downloading and distributing materials like movies, TV shows, and music. It wasn't super common, but every now and then one of these huge companies would come through with a judge and make an example out of people. There were cases that were actively pursued in the LimeWire Napster days. But this is awfully forgiving on the Facebook side of things. From our understanding, torrenting copyrighted work, regardless of seeding, would be infringing copyright law. According to the judge, Meta argued, quote, even if it re-uploaded some of what it downloaded, that doesn't mean it re-uploaded any of the plaintiff's books, end quote. Basically, the defense here is because it's just some bits distributed across these greater files and you can't reconstruct them into any one completed work, it's okay. That's kind of the defense that normal people have tried to use too and have failed to do so in the past. But Meta's defense it's okay. And it's also all over the place. So the trillion-dollar company can't hide the fact that it torrented copyrighted books from pirated sources, but took steps to modify, quote, the config setting so that the smallest amount of seeding possible could occur, end quote, and is essentially now saying that even if Meta did seed the files, this is their defense, the plaintiff has to prove that it seeded fully one of the 13 authors' books. This can be technically complex, and it doesn't help that, again, Meta allegedly, quote, didn't use Facebook's infrastructure to download this data to avoid risk of tracing back the seeder downloader from FB servers. The judge also said that LibGen, which Meta used, is, quote, a reasonable first step towards training an LLM, end quote, even though this is something Meta described internally as, quote, basically Pirate Bay. In his summary judgment, the judge wrote, quote, the plaintiffs say that sanctioning Meta's conduct would encourage piracy by incentivizing other LLM companies to pirate and to support and defend shadow libraries that make stolen works available for free. There's no evidence in the record that Meta or any other LLM developer is actively supporting or otherwise encouraging widespread use of shadow libraries, end quote. The judge writes that this ruling only affects 13 authors, but further down in his summary judgment, the judge says in a contradictory set of language that, quote, the plaintiffs filed this lawsuit seeking to represent a class of all owners of copyrighted works used as a training set for Llama, end quote. Regarding the issue of being transformative, the judge wrote that he seeks, quote, to see if the new work merely supersedes the objects of the original creation, supplanting the original, or instead adds something new with a further purpose or different character, end quote. Here, the judge favored Meta, unsurprisingly, writing, quote, there's no serious question that Meta's use of the plaintiff's books had a further purpose and different character than the books, that it was highly transformative. The purpose of Meta's copying was to train its LLMs, which are innovative tools that can be used to generate diverse text and perform a wide range of functions, end quote. The judge also wrote that, quote, plaintiffs suggest that Llama has no critical bearing on their books, the way criticism or parody would, but critique or commentary on the original are not the only uses that will furnish a justification ultimately qualifying as fair use. To the contrary, a use that enables the furnishing of valuable information on any subject of public interest or renders a valuable service to the public might be justified, especially where that benefit is provided without allowing public access to the copy, end quote. To say a, quote, valuable service to the public might be justified, end quote, doesn't take into account potential harm that Meta AI, which is run by the trillion-dollar for-profit company, can inflict on the public as it trains off of this unconsenting data. This potential harm could come in the way of mass surveillance, deepfake manipulation, automation of jobs, consolidation of power, addiction to social media, overconsumption of natural resources, and more. According to the court document, quote, Meta expects to generate $460 billion to $1.4 trillion in revenue over the next 10 years from Llama. So the judge is saying that Meta's output is transformative, providing elements like summaries, quotes, and learnings rather than providing books to users wholesale. This reminds us a little bit of Cliff Notes or Spark Notes if you go that direction, where it is summarizing something for purposes of education. It is covered under fair use, it's protected, and this is at this point a well-established fact. It also might feel similar in some ways to a book reviewer, where the book reviewer is summarizing the book, or parts of it at least, to make a judgment on the book, and that's protected under fair use. It's commentary. But AI goes far beyond these capabilities. In the example of the book reviewer, that book reviewer probably bought the book rather than just taking it off a shelf and walking out of the store. Or they might have been sent the book by the company that publishes it in order to be reviewed. Meta just took this stuff and in fact asked for a paid option first and then took it anyway. AI goes beyond the capabilities of Cliff Notes or Spark Notes or book reviewers. Not only can it provide you with quotes and summaries of books, it can also break down the themes and answer specific questions and follow-up questions with seemingly beyond human recollection. It can write in the style of the author, it can make stuff up and make it seem like it came from the author. This puts into question the necessity to purchase the original books to begin with. Even the judge admits that, quote, the market for certain nonfiction works, for example, books about how to care for your garden, could be greatly diminished by the ability of LLMs to produce books on that topic, end quote. There's other precedent for this too, which we're seemingly ignoring. So for example, regarding fair use and transformative use in the music world outside of parody, an artist can't just take stuff from other music and then republish it. They need some kind of permission or license or something to use the work in their own song outside of parody. So even if the song is transformative, that's the case. And as an example, one of Diddy's many famous lawsuits, didn't expect his name to be in one of our videos, but here we are. Anyway, one of his famous lawsuits, and one of the least degenerate ones where the police were involved, but not the normal police that are involved, the other police, the band, he was brought to court because he sampled one of the songs of the police, and again, not those police, and ended up having to pay Sting, another name I didn't expect to say in our videos, royalties in perpetuity for it. So the standards are different here. The judge ultimately concludes that this is fair use because the model doesn't provide a market replacement for the book and that the loss of licensing for a, quote, transformative purpose is not cognizable, end quote, and he says the damages were all just speculation anyway. The verdict may set a precedent that would allow other large companies to stretch the terms of fair use and transformative as shields to bypass creator permission and licensing in the AI space moving forward, and yet somehow smaller companies like ours will be continually and disproportionately put in a position to defend their own fair use of materials from larger companies in actual fair use. So the game is set in favor of the mega corporations and of the AI buzzword era and the bubble. If they lose a lawsuit, the companies that are producing these LLMs, they'll just pay the fines later. Couple $100 million, whatever, it's no big deal. They're making billions of dollars. Their market cap is going up by trillions of dollars in some cases. They don't care. So this might also get into some antitrust and anti-competitive territory where if Meta is training on materials other LLMs don't train on for legal considerations because they follow rules more closely, which they don't really seem to, then that could be a different matter entirely. Given the novel nature of the situation that we asked Meta AI, that's right, we did some real hard questions here. Quote, would it be ethical for Meta to torrent terabytes of copyrighted books to train its LLMs off of? That's what we asked. It responded with a giant wall of text about copyright law and fair use. And then it said, quote, on the other hand, using copyrighted materials could significantly advance LLM capabilities, potentially benefiting society. Given these complexities, the ethics depend on one's perspective on balancing creator rights with technological progress, end quote. And in this giant wall of text, Meta AI doesn't weigh the potential downsides it may have, only the upsides. And so again, we come back to the interesting juxtaposition where fair use is a defense, but at least in our situation, in order to leverage it, you would have to go to court. And so at the end of all of this, just another example of the AI bubble and these huge corporations that swing it around everywhere, prioritize profit at any cost, and the cost can be dealt with later. That's it for this one. Thanks for watching. It's an interesting topic on fair use. It's also an interesting juxtaposition for us right now, where it sure feels like the game is rigged against the smaller entities in these particular disputes, because fair use is a defense, and in order to use it, you would need to be in court. And in between that time, or unless that happens, content gets taken off the internet. In the case of YouTube, it's 10 business days. If no suit is filed by the claimant, then it goes back up. But in that time, you're just getting destroyed for views and for visibility in the algorithm. So that's kind of a separate topic, but obviously it's close to home for us with this. And so we found this very interesting because we did try to see both sides of it, but we just can't see Meta's side. There's too much evidence against them that shows they knew this was wrong. And so that's it for this one. Thanks for watching. As always, subscribe for more. Go to store.GamersNexus.net to support us directly, like by buying one of our black market backer tiers on the store. Those will not be available much longer. We left them up because of the Bloomberg situation, but we're going to close those orders pretty soon so we can start shipping everything out. Thank you for watching. See you all next time.